us today. So help me welcome Ken Jarrard.
Good morning. Oh, that was loud. I tend to be a walker, so forgive me if I tend to pace. I'll stay away from the microphone. They told me if I got near the microphone, it'll cause feedback. So good morning again. It is my pleasure to be in front of you this morning. And I will tell you, it is my absolute honor to speak to folks like yourselves who have truly made a commitment to public service. I mean, not only are you talking about public service, you have actually dived in and you have made a commitment by running for, seeking the office that you have run for, and of course been successful in that endeavor. So it's a thrill and an honor for me to be in front of you today, and I so appreciate ACCG and Carl Vinson giving me the opportunity to be in front of you. You know, when I was asked, and I've asked to write this course and prepare this material, and of course I'm always asked to put together the top legal issues facing county commissioners. And I got to tell you, that is a tough course to write because there are a lot of legal issues facing county commissioners. So I tried to do the best I can, and what I tend to emphasize are what I call the bedrock issues. And I've got my clicker here. I had to go into the bedrock issues, so I want you to take a look at the agenda again very quickly. And I want to tell you that we're going to focus on some of these bedrock issues. I've got you for 45 minutes, so I don't have a lot of time. So I've got to distill a lot into this. So if there's anything that I hope I can do here other than whetting your appetite for more, is to put you on notice of some big picture issues that I want you to think about. And then with respect to when you go home, I want you to talk to your county attorneys in the counties that you work in. Okay, because I'm not going to be able to go over everything I want to be able to, but again, there's going to be other opportunities for training, and sometimes ACCG and Carl Vinson will give me the opportunity to come back and train you some more, and we can get into more of the weeds on some of these great issues. So in coming up with this course, I wanted to talk about the sunshine laws, I wanted to talk about ethics, I wanted to talk about immigration, and if we have time, I want to briefly talk about campaign finance. Now, I will tell you two things. Number one, I love talking about the sunshine laws, open meetings and open records. It's something that's near and dear to my heart. I love that area of the law. I think it is a foundational bedrock issue. If this was a pyramid, your government service was a pyramid, I would say that open meetings, open records is on the foundation of the pyramid. There's another speaker, however, that's going to follow me, who is the State Attorney General. And he is going to speak on these topics as well, particularly open government. So listen to me, but when it comes to open government, since he is the chief regulatory authority in Georgia on that issue, I would particularly pay attention to him as well and what Mr. Owens may have to say to us. With respect to ethics, you saw the chairman for Cherokee County just talking about ethics. Again, one of the honors and privileges that I have of speaking to you in new commissioner training is I get to speak to you before you begin your service. And I tell you, it is so important if we can get on the front end of some of these issues and sort of put these out there before you begin your service. So then you sort of always have this in the background, always thinking about ethical propriety and ethical considerations because you're entering a new world in government service. And I want to make sure that those are in front of you. Immigration, E-Verify, and Save. Now that is not what I would call a foundational thing. That's not a foundational law. But what it is it is a law that is very important to the General Assembly of the state of Georgia as they have acted in this area, and it deals, of course, with the citizenship of individuals that the governments do business with. And the reason I think it is such a critical legal issue is because it's relatively new, and because I think some local governments may not be absolutely embracing it or getting that law perhaps as well as they should. And so we just want to make sure that everyone leaves here and has that again on the forefront of their mind, and they can go back to their respective jurisdictions, and they can then in fact ask their attorneys, what do we need? Or their procurement professionals, what do we need? Or their HR professionals, what do we need to do to embrace this very important law to make sure that our county, our local government does not get in any trouble with respect to some of the oversight agencies that are looking at that. And finally, with respect to campaign finance, that is, of course, something that may be near and dear to your heart. Most of you, having run for office, are probably already fairly familiar with some of the disclosure requirements that you have. But if anything, what I want to do is just put into your mind maybe some deadlines that you have coming up with respect to the end of the year, with respect to campaign finance. All right, so with respect to our slideshow, let's go. Sunshine laws, open meetings, open records. I don't suppose that I even need to say we all know what at least the objectives of the Sunshine Law is. It's sort of neat because it sounds a whole lot like what it is, right? It's the notion of inserting sunshine or daylight, or how about this, transparency in the operation of government, right? I mean, we can all agree, and that's sort of how we came up with this sort of colloquial phrase, the Sunshine Laws. There's actually a statute, and I won't regurgitate it, but that's what it is. So why do we do that? Again, you know, the Attorney General is going to come and talk to you about some of the brass tacks, what constitutes a meeting, and some of the specific statutory things. I think what I'd like to do is pull back a little bit and talk about some of the broader public policy reasons why we do this. Why is it so emphasized in Georgia that we need to embrace the notion of open government? Can we agree in this room that we are a nation, that our government is of the people, by the people, and for the people, correct? I mean, we can agree that that's sort of a foundational element as well. Well, I think the General Assembly might say, how can the people be involved, participate meaningfully in their government if they don't know how the government is doing its business, right? And I also think that you might hear something like this. Government that is done behind closed doors or in a clandestine environment or with everything done in private, okay, does that in fact foster confidence in our government? Does it foster citizens embracing government initiatives? And I think we all know the self-evident answer. The answer is no. It doesn't. And so this great body of statutory law, which by the way was fairly significantly modified in just April of this year, one of the first big rewrites of the law in some time. And so now we have all of these defining legal principles that you need to be very in tune with, okay, because they will dictate and guide a lot of how you perform your public functions. And if you come to some of the additional training, when we literally will take a half a day and we will get into scenarios and we will show videos and we will get into some of the brass tacks on how to comply with the Sunshine Law. But let's just step back one step further and say this. When I have people say, Ken, you know, how am I supposed to comply with these statutes? And I've actually had a commissioner say, you know, Ken, just tell me the rules and I'll follow them, but I need to know what the rules are. All right. Well, I don't have time to walk through every rule today, and maybe the Attorney General will, but I will say this, because I start most of my lectures this way. A significant component of complying with the Act is simply embracing the principles behind the Act. And let me say what I mean. There's two ways to comply with anything, right? There's you can go along with it, or you can fight it and resist it and look for ways to get out of it. If you can embrace the principles of the Act, and that is, the principle of the Act is the overwhelming majority of your action as a government official will be out in the public for the public to inspect and review. If there is an exception to that, it's limited, very limited. And we're going to go actually into a few of the exceptions, but the overwhelming philosophy is if you're taking official action, it's going to be out in the open. You know, sometimes I'll get questions during my seminars, you know, can I phone in? Can I call in to the meeting? Of course, I will say that the Open Meetings Act actually was changed to allow you to do that on maybe 2 occasions per year, but I'm not going to talk about the telephone requirements. I'm going to say, when I have folks say, why can't I participate remotely in meetings? And one of the answers is because there is something profoundly different between phoning in and sitting on a station in a board meeting room looking out at a room full of red shirts, staring at them. They've got their pitchforks or their torches, and they're upset with you, and they're staring at you, and you're supposed to raise your hand and make a motion or a second or cast your vote, and it's just different. Can we just agree on that? It's just sometimes it's harder, folks. It just is, and that's on purpose, right? That's on purpose that it has to be that way. So I'll say this, so much of it is simply embracing the objectives of the act. Once you decide in your head, look, everything I need to do, subject to some limited exceptions that I'm sure my county attorney will brief me on, is going to be open, then you are well on your way to getting the sunshine laws in the state of Georgia. And here's the bottom line, folks. I'm a county attorney for multiple different jurisdictions. My law office represents Forsyth County and Cherokee County and Barrow County, and I even do some municipal work as well. My objective, my goal as a county attorney is not to get in your way. I know a lot of my clients feel otherwise. Oh, if I want to hear no, I'll just call up Ken. If I want to hear no, I can't do this, I'll call up Ken. That's not at all your attorney's objective. The objective is to, in fact, make sure that you can achieve your policy objectives that you came into office to do. But my objective is also to make sure you do them within the boundaries of the law. All right? Now, it's very easy to say no. So as your county attorney and you call your county attorney and they want to say no, it's a little harder sometimes to come up with a creative yet legal way to accomplish your objective. So always be mindful of that as well. But your attorney, your representation's objective should not be to get in your way of accomplishing your vision for your jurisdiction. No one elected me to do anything. They elected you. However, my job, and I will be failing at it, is if I do not assist you in fulfilling that objective within the boundaries of the law. That's my job. So you call your county attorney and they will assist you, I believe, in attempting to fulfill your vision in a way that covers the law. And one of those, of course, is in the realm of transparency. Now, the Open Meetings Act works in conjunction with, and I think is just the other side of the coin of, the Open Records Act. And we're going to talk a little bit about the Open Records Act as well, but let's keep going on with respect to open meetings. I don't know, I think what we might try to do is at the end of this, if we have some Q&A, perhaps a couple of questions if we have some time, so maybe we can just do that at the end of the presentation. All right. I want to talk very quickly. You know, I started this particular portion of my discussion by saying that everything is going to be open. It's interesting what the new Open Meetings Act does. It basically divides non-open events into three different categories. Now I want to stop right there. Can we agree that your official action, the official actions that you take as a member of the Board of Commissioners that you've been elected to serve, are going to be, those official actions are primarily going to be taken out in the open? And in fact, I will say that if you come back to subsequent seminars, you will learn that typically if you get together with a quorum, right? A quorum, typically it's going to be 3 if you have a 5-member board, more if you have a 7-member board. But if you get together as a quorum, you've sort of got to be on guard, right? You've got to watch what you're doing. Some of y'all are shaking your heads. Good. I mean, you're new to this and you already know, right? You got to be careful, because let me tell you, folks, first of all, are watching you. Embrace it. It's just the way it is anymore. In fact, there is a level of scrutiny on public officials that is heretofore, I don't think, ever been seen. And let me tell you, in the age of social media and networking and the internet access, it is unprecedented. And that's okay, because I've got you today before you even take office, so I can tell you all these things so you can go into office fully aware that you are going to be looked at. And your associations are going to be scrutinized. I have seen in some jurisdictions, literally people walk around. What does everybody have now on their hip? They've got a phone. What is the phone also? It's a camera. So we literally have jurisdictions where people will walk around following elected officials in certain events with a camera, looking for that perfect shot, that perfect snapshot when they assemble with 2 of their other fellow board members, and bam, you know what they've got? It starts with a Q. They've got a quorum right there. That's right. Okay, so here they are at the, gathered around the water cooler at a non-called meeting, and there's a quorum, right? So we can know that there are those situations where you need to be mindful of. And again, we have a lot of fun with this at the subsequent training where we talk about things that are or not a problem. But I want to talk to you very quickly about what the Open Meetings Act defines as non-problematic gatherings of your commissioners, okay? Everything else is going to be covered by the Act, but I want to talk about these very quickly. It's interesting what the Open Meetings Act says. There are actually gatherings or assemblies of your fellow commissioners that are literally exempt from the Act altogether. In other words, they are absolutely excluded from the Open Meetings Act. And we'll talk about those very quickly. And number two, you have gatherings or assemblies of your board members that are simply exempt from the definition of a meeting. So again, you may be thinking, I don't understand the difference between the two. You will in just a moment. I'm not going to talk about executive session because I've had the benefit of seeing the Attorney General's presentation, and I know he'll be talking with you about the executive session. So I'm going to leave that for him. With respect to those things that are exempt from the definition of a meeting, a gathering of the members of the governing body for purposes of making inspections of physical facilities or property. In your tenure as a board member, there may be instances when you gather with other board members to go look at the real property of your jurisdiction or the physical facilities of your jurisdiction. You go to do that. You can do that and don't have to call it an actual meeting. Now, of course, you cannot transact business. You can't take votes. But if you go and do that, that's not considered a meeting. Gatherings, number two, gatherings of a quorum for attending statewide, multi-jurisdictional, or regional meetings to participate in training. Literally, the General Assembly carving out exemptions to augment and enhance your training experience. The understanding is that most of you will be going to training to learn better how to be a commissioner, to learn better how to bring your vision to bear, and you shouldn't have to worry, at least with respect to the training itself, about the Open Meetings Act. So a very practical, pragmatic exception to the Act. And then, of course, a gathering of a quorum of the members for the purpose of meeting with officials of the legislative or executive branches of the state or federal government at their offices. So literally, you, as board members, can go and meet, for instance, with your local delegation at their office down in Atlanta or wherever, and you don't have to actually call that a meeting. You see the points I'm making. One thing you ought to be ringing in your head right now is, wow, those are very specific exceptions. They are. That's right. They are very specific exceptions. Gathering of a quorum of the members for the purpose of traveling to a meeting that is otherwise exempt. Remember that, going to a seminar for traveling, going to inspect physical property or facilities. Well, in the age of enlightenment, when it comes to the environment, you can all now drive together. Rather than have to take 5 different vehicles. You can drive to that event together without constituting a meeting under the Act. And finally, gathering of a quorum of the members of a governing body at a social, ceremonial, civic, or religious event. Okay, so inevitably, you as a board member will get asked to go and attend a volunteer appreciation banquet. I get this question every time I teach this course. Can I go, because I know my other board members are going to be there, can I go and attend the volunteer appreciation banquet? And the answer is yes, you can. Is that a meeting? Well, what does it say? It says that you and a quorum can gather for a civic event. Now, there's a but wait. Of course, there's always a but wait. There's a but wait with respect to this wonderful accommodations under the law. And the but wait is that any of the above gatherings will offend the Act if the primary purpose of the gathering that you're attending is to avoid the requirements of the Act. So just to have some fun, let me roll out my scenario again. You're going to your volunteer appreciation banquet. You have a nice little exception under the Act because that is in fact a civic event. But while you're there, you happen to see 2 other commissioners, and that of course would constitute a quorum when the 3 of you get together, and there's this really crazy landfill zoning decision that's coming up. And what you'd like to do is huddle in a corner with those individuals and maybe talk about that landfill and see if you can gain some consensus on how each other is going to vote and perhaps even work it all out at the volunteer civic event. Is that appropriate under the Act? No, right. Okay, so we're already there. So you are already there. You know what the Open Meetings Act is all about. So all of these limited exceptions that I'm walking you through have the big caveat. And that is if the purpose of taking advantage of them is to otherwise avoid the requirements of the Act, you can still get in trouble. So the individuals with the iPhone camera walking around at the civic event who takes a picture of you gathered as a quorum still not have a leg to stand on. So I just ask you to be mindful of that. And again, go back to our default position. What's the default position? I am embracing the public policy behind the act, and that is all of our official business, subject to very limited exception, is going to be done out in the open, subject to lawfully called meetings. Okay? So that was just some fun going through these sorts of assemblies that are literally exempted from the definition of a meeting. We're not going to talk about executive session, because I'm going to let the Attorney General do that, of course. There are also some exemptions or some language in the Act that says not only is this not a definition of a meeting, it's not covered by the Open Meetings Act at all. One of them is mediation involving neutrals. Now, some of you may, even in your status as a candidate for office, may have watched your jurisdiction dealing with the local option sales tax. Maybe some of you watched your jurisdictions grappling with Lost. Well, a lot of those jurisdictions grappling with Lost and their respective municipalities may have triggered mediation under the Lost statute. Well, a mediation between two adverse parties involving a third-party neutral, right, a mediator, you as the government can assemble for that mediation, and it's not a meeting at all. Okay, so you can do that. You can assemble, you can negotiate, you can have that mediator try to work out consensus, and that is not subject to the Act at all. However, any decision that arises out of that assembly has to be approved in a lawfully called open session before it is binding. It's a great compromise in the law. The law is understanding that you, as an elected official, as part of a corporate body, needs to be able to mediate in a way where there's going to be information flying back and forth, and everybody needs to speak candidly. Therefore, perhaps having that out in an open session would not be conducive to resolution. But they also understand that we're going to let you mediate behind closed doors, but if you want to be binding, you got to bring it out, and you got to stare your citizens right in the eyes, and you got to vote in favor of it in an open session. It's a great compromise that balances both the legitimate interest in settling and resolving disputes with the legitimate public interest of knowing how and what you've done with respect to that dispute, how you're going to bind your jurisdiction. And finally, two other subject matters that are literally exempt from the Act. And quite frankly, I'll start on the second one. Email communications. Email communications are exempt from the Act. There has been or was quite a bit of discussion about whether when commissioners, particularly elected officials, part of a body like you are, email online, whether those email exchanges, particularly involving a quorum, could themselves constitute a meeting. Now you may think, you got to be kidding me. How can that constitute a meeting? Well, because can people come to consensus on email? Can there be like an exchange of information on email, almost a dialogue on email? Yes. Is it spontaneous like in a real meeting? No, it's not. But over time, can folks debate issues online? Yes, they can. So this was a real debate, and it was not entirely academic. There were merits to both sides. So the way it landed in the new rewrite was, and I attribute a lot of this to ACCG's efforts in trying to get clarity on the issue. And again, remember what one of my commissioners told me? Just tell me what the rules are and I'll follow them. Okay, we need to know what the rules are. The rule is those email communications are not subject to the Open Meetings Act, but they are subject to the Open Records Act. So if, in fact, you have that dialogue with your fellow commissioners, just be mindful that a citizen is going to have the right to pull that and see what you wrote and see what you said. So be mindful of that as well. And then, of course, incidental conversations unrelated to the business of the county. Now, that's always been the case. It's now set forth with specificity in the Open Meetings Act, but it's always been the case that if you gather with 3 members of your board. And again, I'm using 3 just because it's an easy number, and typically a lot of you may have 5-member boards. But if you gather with 3 members and you want to talk about professional football, and that's what you choose to do, can you do that and it's not considered a violation of the Open Meetings Act? The answer is that you can. Now, is that the wisest thing to do in the era of iPhones and cameras and taking photographs of you while you're huddled talking about professional football? No, not really. So be aware of that as well, that even though you may be speaking about something purely incidental to your government business, you still might have to explain what you were doing to somebody if you get called on it. All right, so that's just some of the groundwork for the Open Meetings Act, and we're going to go on to open records as well. Just as a matter, does anybody have any open meetings questions that they just can't wait till the end of the course to ask me? Just in case, I just want to, sometimes I'll have a question off the top of my head, and if any time passes, I'll forget it. Okay. All right, fantastic. Open records. Again, the other side of the same coin, and that is government of the people, by the people, for the people. You need to see the documents of the county and see how the county is doing its business. I just really briefly want to touch on 1 or 2 points here because I've got 10 minutes left, and I want to make sure I at least cover ethics and E-Verify and Save. Here is the key. I want to go ahead and say this now. And this may be the only thing I talk about with respect to open records because the Attorney General is going to talk about some of the exemptions under the Act and some of the more brass tacks. I just want to say this. A lot of people with respect to open records get caught up and confused on what in fact is a legitimate public document or a legitimate record that is subject to the Act. Because I get this question a lot at the seminars that I teach. They want to know about things like, now if I write an email about a matter of county business, but it's on a personal email address at my house with no county money at all going toward the electricity or the internet account or the computer that I wrote it on, is that a public record or a public document if it in fact pertains to county business? And the answer is yes. The answer is it is a county record, or it is a record disclosable under the Open Records Act if it is prepared and maintained or received by an agency in the performance of a service or function by or on behalf of the agencies. Look at that language again, prepared and maintained or received by an agency. You see, the Open Records Act doesn't really care so much where a document is prepared or who funded it. They care about what it is about. What is the document about? And I always have fun with this, but if it was as easy to sort of get around the Open Records Act by doing everything on a private email account, you know how much, like 99% of all county business would be done? Be done on private email accounts. If that was all it took, would be just to make sure that you did your email on private business accounts, it'd be very easy to get around. So I'll say this to you, if you walk away with one definition under the Open Records Act, it would be to know what the definition is of a document, and that is if the document is prepared and maintained or received by the agency. Who paid for it counts much less than the subject matter of the document. Okay? Open records, and again, the Attorney General is going to get into that. Yes, ma'am. Yes. Yes, ma'am. The question was, I'm a financial planner and I have on ostensibly the personal or your business-related email a lot of privileged and personal emails from clients that may in fact get mixed in on the same email account with emails or communications from constituents or officials, and so they're going to be blended, if you will, onto this private account. Is that fair? How do I keep them? And the answer is that I've got a very good answer. If it is something that you're preparing at home, if you are dialoguing with constituents on your personal machine and then dialoguing with a client in a very protected, confidential way about your business, just because those emails to the constituents about the matter of county business is going to be subject to the Act, those personal emails are not. It does not open up your entire computer to disclosure. You understand what I'm saying? If it's done on a private machine, my position is it only applies to those emails that literally have to do with the business of the county. Now, contrast that with if you are on a public machine at the county administrative offices, and let me give you the reverse scenario. You're doing personal business on a publicly funded, taxpayer-funded email account and taxpayer-funded machine. My position is all of that is fair game under the Act. Does everybody see the distinction I'm making? So in that scenario, it does matter who is in fact paying for it.
What triggers the onset of this rule? Right now we haven't been sworn in, so we're officially not commissioners. So emails prior to the swearing in, are they applicable to this?
To the extent that you're receiving something from a government official, or to the extent that you are sending it to a government official, it would still be subject to the Act. But to the extent you're just preparing it and exchanging communications with a private citizen, no. I mean, until you're actually in office, that's when this is going to be applicable, which is why it's so nice to speak to you about it now, because I will tell you, folks, I'm going to leave the open records topic in just a second. But I have done this a long time. And I have gotten up, and they've been kind enough to invite me to this seminar and speak to commissioners for a long time. Some of the best people I know, the most decent, ethical, decent people I know, get behind a keyboard and lose their mind. Okay? So I would ask you that when you are typing that email, when you get into office and are now subject to the Open Records Act, please don't lose your mind. Please remember that anything delivered electronically, forget about pen and paper. Stuff that's delivered electronically is like, for some reason, it appears to never go away, ever. And it's subject to record retention requirements, and it's of course subject to being reply all and forwarded and all over the blogosphere and all over social networking instantly. Just be aware that most of the things that you write that pertain to county business are going to be subject to the Open Records Act and are going to be circulated all over creation. One or two more questions and we'll move. Well, I have a slight variation on that. My rule is, in layman's terms, is if you write an email before you hit send, would you mind if your wife, pastor, or the editor of the local paper saw it?
Just one moment.
With technology the way it is, with laptops and iPads and such, if you say you're at the county office and you got your own personal computer, but you're logging in through their system, would that make your personal stuff subject to this?
If you're logging in through the county's server, but it's on your personal computer. You know, it's funny, I get variations on these questions, and it's like a Wendy's hamburger. There's like 30 million combinations that you can like bring to bear. In that scenario, if it is a private computer, it's your own. Now, you may be logging into, if it's your own machine, my position still would be that the only things that are going to be subject to the Act are going to be things that are relating to the operation and business of the county. I could be persuaded otherwise, but in the 2 seconds I'm having to answer this question, that is my position. And it may be totally fact-driven.
Can you put that in writing?
Absolutely not. And I'll meet with you offline about it, and we'll talk about it.
Good morning, Shana Rooks, Clayton County, and I'm a lawyer. So, does this apply to us before we're in office? Since we are commissioners-elect, do the rules apply before we take the oath of office?
Well, again, that's kind of going back to the gentleman's question over here. Let me make sure that I'm not inconsistent with what I said. What is critical is whether the communication or document pertains to, prepared or maintained by or on behalf of the agency. Now, if you are simply having, as a commissioner-elect, a private conversation with another citizen, I don't believe just because you're a commissioner-elect, that suddenly has risen to the level of now it is on behalf of the agency. I think come January 1st, It does, but I don't believe, but now, even if you're a commissioner-elect and you are communicating with a commissioner in office, I think that is. Does everybody see the distinction I'm making there? So I don't think that just your generation of a document in your status right now elevates it to being in the course and scope of the operations of the agency, but you're about 20 days, 25 days away from that being the case. Okay, wow, okay.
Ken, I'm an IT guy, so I'll give you a word of caution. If you're using a private computer on the county network, that message has the county's IP address on it. It'll be very difficult to prove it was done on your own computer.
Well, that is exactly why I qualified my answer with 15 layers of qualifications right there for that very comment. So that's a great element, and of course that's something we have to think about with respect to when that request is made. Any other questions? Yes.
It's really not a question, but listen to this talk about folks and what their messages they're sending back and forth before they are sworn in. You might touch briefly on the difference between application of the Open Records Act and discovery in a piece of litigation that might stem out of that. For example, pre-discussion of a zoning matter that they vote on after they take office.
Yeah, Charlotte's question is a good one. Just because the Open Records Act may not be perfectly triggered, to the extent that that's a great scenario, quite frankly, is a zoning matter. If you get in the office in January, right, and one of your first orders of business is to take official action with respect to a zoning decision, and let's just say, for instance, you deny the zoning, and of course, inevitably, there'll be litigation by the property owner whose zoning was denied, and they, in fact, seek civil discovery against your communications that you took. Civil discovery doesn't care about the Open Records Act limitations. In civil discovery, they will likely, subject to perhaps some sort of an objection that could be raised by the lawyer, which may not be applicable, they would have the right to see if you are, in fact, straw polling or otherwise taking or coordinating your decision-making with others before you take office. So just be mindful of that. That's a great point. The Open Records Act is not the only vehicle by which individuals can get records. Civil discovery can snag them as well, and that would not worry one bit about whether you were an elected official. So thank you for that. That's a good point. I've got like maybe 3 minutes left, and I have basically just not been able to touch on a lot of my course. So let me just talk to you very quickly before I stop about ethics. And then all I'm gonna tell you as I end is that there is material in your PowerPoint about E-Verify and SAVE and campaign disclosures. Review it. Call me with questions. I'll take your phone calls and I'll answer them. But I want to talk about ethics very quickly. Most of you are going to be in jurisdictions that have an ethics ordinance, okay, ethics code, and that's great. But this state enactment, this is in the code, has some really great language that I just want you to think about as we end. Okay, I'm not going to talk about bullet point number 1, putting loyalty to the highest moral principles. I know everyone here is going to do that anyway. I'm not going to tell you to uphold the Constitution. I know that you will do that anyway, and I don't have time to regurgitate all of the constitutional principles that may apply to your office. I want to talk about the brass tacks. I want to talk about number 5, never discriminate unfairly by the dispensing of special favors. All right, special favors. Special favors imply special access. Special favors imply that certain people get certain things that are not commonly granted. We, as the government, are supposed to have one touchstone with respect to how we interact, and that is everyone is treated the same. And that's why that ethical prohibition with respect to special favors is in there. Special favors or privileges anticipate that the government is treating some individuals differently, presumably better than others. We are to treat people as the government equally. Similarly situated must be treated the same. Number 2, and again, this is not in order. I'm actually on bullet point 6. Make no private promises of any kind binding upon the duties of office. Anybody see anything interesting? We just finished discussing openness and sunshine. No private promise. no private promise binding upon the duties of office. If you have made a private promise to me that you will take some sort of official action, if I'm in the gallery at your meeting watching you take action and you vote in favor of something, and even if you have debate on it, but there is a private process, a private promise that is driving your decision making, do I as the constituent know why you acted really the way you acted? Do I legitimately know why you took the action that you took? The answer is no. No private promise. Number 7, engage in no business with the government, either directly or indirectly, which is inconsistent with the conscientious performance of government duties. Okay, engage in no business. The concern being what? The concern being that if you engage in business that affects your ability to impartially and neutrally and reasonably act in your official capacity when you take the actions that you take, what might be driving your decision making other than the public's interest? Could it be a personal motive? If there's one touchstone that just permeates these ethical rules, that is that your personal motivation should not get in the way and not, in fact, drive your decision making. It ought to be what you, acting impartially, acting reasonably, and in the good exercise of your legislative discretion, believe is in the best interest of your citizens. Number 8, never use any information coming to you that is confidential in the performance. Sir. You mean that, that public action? The question was, is what if you happen to know that there is in fact individuals that are making decisions based or to advance their own personal business dealings? First of all, how do you confirm that that's true? And I guess the next question would be, and then how do you stop it? Is that fair enough? Okay. How do you confirm that it's true? That is going to be based on a whole host of factors. For instance, I think you just said that it goes on all the time. I hope that's not accurate. But if it is accurate, there's got to be a paper trail. I mean, you know, for instance, most governments are driven by paperwork. There's going to be procurements. There's got to be purchase orders. There's got to be contracts with entities. All of those things have to be memorialized and placed on the minutes of the assembly. And to the extent that, for instance, you tell me, I know, for instance, that John Doe LLC, that we just awarded an appropriations contract to, I know that's owned by the brother-in-law or the relative of one of my council members or my commissioners. That's a fact that you would unfortunately have to get to the bottom of. Now, if it's truly going on, it may not be you that's investigating. It may be one of the investigative arms of the state of Georgia that's looking into it. But I mean, that's the sort of thing that you would just have to maybe call me about later and we can talk about more. But again, ideally, we don't want that to be going on because what that would suggest is public action is being taken based upon a private gain, a private profit motivation. And again, the documentation, the paperwork is the key. That's why government is so concerned not about efficiency is good, but process and accountability and transparency are the key. 2 more questions and then I'm going to have to stop. Yes, sir.
Because in our ethics, we define family as wife and children, basically. And we've had some issues where some votes went on and it affected second cousins and things like that of the commission. So I would like to hear your interpretation of this.
Well, to the extent that you have an ethics ordinance and it defines family to mean a certain thing, whatever the line or the line of dissent is, that's going to be very controlling. If I'm a public official and there's an ethics ordinance in my jurisdiction and it defines family in a certain way and I govern my behavior based upon the codified, adopted code that is in place, that is a great defense for me. Okay? I understand. But there is a local enactment that clearly defines that And I think that's a reasonable place for me to be as a government official, is I am simply doing what the local enactment allowed me to do. So that's my position on that. Yes. The question was, if you're on a board of a charitable institution and you're taking action that benefits that charitable institution, is that something that you should take into consideration? And the answer is yes. I believe that it is something you should take into consideration. Again, if you were to ask me, well, what's the guide? How do we know? And again, I'm not saying that flat-footed means you have to recuse, because I would need to know what the official action that is being contemplated is. But you always need to think in the back of your head, is my relationship with whatever the business of the county is such, I have a relationship that affects my ability to act impartially and freely in the exercise of my legislative discretion? And if the answer is, I don't. I mean, I am impacted by my affiliation with that nonprofit. I am impacted. I want that nonprofit to succeed. I want them to get this grant. I want them to get this money. Then that's when you need to maybe consult with your county attorney and say, should I recuse? Should I disclose and not recuse? What should I do? All right, these are great questions, and I wish that I could answer more of them. I wish I had you for all afternoon, and I don't. But if you come back to some subsequent training, we will do that. Thank you very much. It's been a pleasure to be in front of you this morning.